Hi everyone, and welcome to class 23. Today we're going to be talking about statements of an opposing party co-conspirators. This is the exemption under 801 D2E, and this is the last of the 801 exceptions that you all are going to be learning about. So the first thing you need to be able to do when applying 801 D2E is determine what defines a conspiracy. So bear in mind that the definition of a conspiracy for this exception is much broader than in criminal statutes. It simply means a joint or common venture. The book gives you plenty of different examples. An example could be somebody who robs a convenience store and then runs outside and jumps into a friend's car, and the friend is the getaway driver. That would be considered a conspiracy or joint venture for purposes of this rule, even if the friend is not charged with anything, even if they are separately charged and not charged with a criminal conspiracy. The declarant and the defendant must have agreed to use joint efforts in some way to reach a common goal. So you saw an example of this in your textbook reading for today in United States versus Gill. In that case, you had two individuals, Villegas and Gill, who were jointly tried for distribution of heroin. Villegas had made incriminating statements about his co-defendant Gill to an informant during the course of this drug distribution. Villegas ultimately was acquitted, however, of the conspiracy charges because of entrapment. And so, of course, Gill then argued that because there was no conspiracy charge, because that charge was dismissed, Villegas' statement could not come in against him. The Court of Appeals ultimately considered but rejected this argument based on the expansive definition of conspiracy in 801 D2E. Gill could not have been convicted of substantive conspiracy. That was true. However, there was still evidence that the two men had worked together in this common scheme or joint venture to sell heroin. So because of that, the court found that it was appropriate to hold defendant Gill, accountable for statements that Villegas had made to the informant. Now there are three requirements to admit out-of-court statements under this exception. The statement is admissible against a party if it was made by a co-conspirator, or again, it might be easier to think of it as made by a joint venturer rather than co-conspirator. If it was made during the course of the conspiracy or joint venture. And it also has to be made in furtherance of the conspiracy. It doesn't have to actually succeed in furthering the conspiracy in any way, but it has to be made in furtherance of that conspiracy. So we're going to explore the latter two elements, during the course and in furtherance, a little bit more with a series of hypotheticals based on a real-life, true Hollywood crime. So to discuss this exception, we have what I refer to as the Hollywood bling ring. We have a group of high school classmates who lived in Hollywood, Beverly Hills area, and ultimately they were arrested and charged with stealing jewelry and designer clothing from various homes of high-profile Hollywood stars like Paris Hilton and Lindsay Lohan. The teens had committed these crimes after turning 18, so we don't have to worry about any juvenile issues. But ultimately what they allegedly did was they studied fashion magazines and websites. They identified items from various celebrities that they liked, that they wanted to take. They stalked out the homes. They checked the websites to see when the celebrities would be gone and to determine access. And when they had the opportunity, they broke into the homes and they took the things that they liked. Now they were caught in part because of these webcam, security cam images that were taken of the teenagers breaking into some of the homes. And then, of course, after the burglary, they quickly started bragging to their friends about how they had gotten into the home and stolen goods. And so that allows us to have a lot of fun with hearsay for this story. So here's Alexis Neers. She is one of the women who was arrested for this crime, and some of you, I don't know how much you're into reality TV. I went through a period where I watched a lot of it, unashamedly. And if you do, you might recognize Alexis Neers because she and her mother were featured on a short-lived, I think it was an MTV show called Pretty Wild. So she obviously has lived up to the theme of that show. But in any case, in a public statement to the press just after her arrest, Alexis Neers declared her innocence, and she put the blame completely on others, one of the others being Nick Prugo. So here's an excerpt of her public statement after her arrest. She says, "I did nothing. Nick did all of these burglaries. He did every single burglary. He told me this after the police let him go. Nick is blaming people, trying to get the blame off of himself." Alexis later pled no contest to one count of burglary, and in the summer of 2010, she ended up serving 1 month of a 6-month sentence. She was then released on probation. She ultimately violated probation and was returned to a drug rehab program for 1 year. Nick and 4 other individuals were indicted, and they were charged with multiple counts of burglary and conspiracy in early July of 2010. They all pled not guilty. Rachel Lee was somebody who was involved. She later pled no contest to 1 burglary and was sentenced to 4 years in prison. And then at least as of October 2011, the other 4 members were still awaiting trial. So let's suppose that Nick goes to trial and the prosecutor calls Alexis, who you just saw on the other screen, but she refuses to testify. Can the prosecutor introduce Alexis's public statement at Nick's trial? So let's start the question. You've got 4 options. Yes as a co-conspirator statement, yes as a public record, yes as a statement against interest, or no, not at all. And just to remind you, she said, "I did nothing. Nick did all of these burglaries. He did every single burglary. He told me this after the police let him go. Nick is blaming people, trying to get the blame off of himself." Okay, why don't you pause the video, answer this one, and then press play for the explanation. Okay, the correct response is no. This does not come in under any of those 3 exceptions posted above. This is simply rank hearsay. We probably could offer proof that Alexis and Nick were part of a conspiracy. In this statement, Alexis denies any involvement, but then as I told you, she later pled guilty or no contest. Plus, there were statements from Nick and others that could establish a conspiracy. But this statement clearly was not in furtherance and during the course of the conspiracy. This was basically bragging after the fact, and I believe I told you it was after she was arrested, right? So the conspiracy had clearly come to an end. Bragging is generally not in furtherance of any conspiracy. And in this case, she's really just pushing the blame onto somebody else. That can't be said to be in furtherance of a conspiracy. To be in furtherance, a statement must really be meant to further or secure some sort of objective of the conspiracy itself. In this case, the conspiracy involved stealing jewelry. The public statement, the public record exception also does not apply. This is a public statement, but that's not the same thing as a public record, so you have to know the difference. Even if the statement ended up in some sort of public record, which we don't have the facts to support, Alexis isn't a part of a public agency or a business for purposes of the business record exception. So this is just simply her personal statement. It wouldn't fit into business or public record exception. Nor is the statement admissible as against her own interest, because it really isn't against her interest. The statement completely denies responsibility and shifts blame onto Nick. Now suppose that Alexis comes to court and makes exactly the same statement in court. She's testifying live, but there's an out-of-court statement that's embedded here, which I have underlined. So she says, I did nothing. Nick did all of these burglaries. He did every single burglary, and here's the out-of-court statement. He told me this after the police let him go. Right, so then when we analyze the statement, who's the speaker? The speaker is Nick. So Nick is the out-of-court declarant, and he's made a statement to Alexis. The statement being, I did every single burglary. So that's the statement we are going to analyze. We want to figure out if that particular statement made by Nick out of court is admissible against him in his trial. So that is the question. Suppose Alexis comes to court and makes the same statement. She's testifying live. There's this out-of-court statement embedded. He told me. Is that admissible in Nick's trial? So let's start the question. You have 4 options again. No, it's hearsay, or only if Nick is unavailable, or only with a limiting instruction, or yes. Now's a good time to pause and answer this one. Okay, now that you've had a chance to think about it, the answer to this one is yes, it can come in against Nick. And hopefully you've thought about why that is, why the statement can come in against Nick. This is something that we talked about in our last evidence module. So the reason this can come in against Nick is because it's his own statement. So this would be admissible under 801 D2A, which we talked about last time. This is simply an opposing party's statement. We don't need to worry. I expressed to you last time that opposing party statements are extremely broad, or that exception is extremely broad, so we don't have to worry about unavailability. We don't have to worry about a limiting instruction because, again, this can come in for the truth of the matter asserted. Let's take a look at another member of this conspiracy. So this girl's name is Courtney Ames. She was arrested because police ultimately searched Nick's computer and they found this picture of Courtney holding a large amount of cash on Nick's computer. So let's suppose that when Courtney was arrested, she talked to the cops and she said, Rachel Lee planned everything. I just drove her and Nick sometimes. And just so you know, this statement is imaginary, but it certainly could have been made because several members of this conspiracy pointed the blame or pointed the finger at Rachel Lee. So ultimately, this statement did not get Courtney off the hook, but it helped to ensnare Rachel. So prosecutors actually went after Rachel Lee first. So Rachel agreed to a plea deal, as noted, but before agreeing to the deal, both sides have to sort of think about what possible evidence might come in at trial against Rachel. So suppose that you were the prosecutor in this case and you know about Courtney's statement, but you also know that she probably will refuse to testify live at Rachel's trial because of her Fifth Amendment privilege. Would you be able to introduce Courtney's statement to the police in which she identified Rachel Lee as sort of the mastermind or the ringleader behind this conspiracy? So here's your next question. You have 4 options: yes as a public record, yes as a co-conspirator statement, yes as a prior inconsistent statement, or no. Take a minute to pause, think about it, answer, and I'll see you back here in a moment. Okay, so for this one, the correct answer is no. This statement cannot come in under any of these 3 exceptions against Rachel Lee. And really, this is for the same reasons as in the Nick Alexis example. Courtney's statement is certainly a part of a public record for purposes of A because it's contained in a police report, but it doesn't qualify for admission under the public record exception because it's a third-party statement. And so we talked in class about the difference between a third-party statement being made in a police report, which would lead to multiple hearsay, double hearsay, versus the police just drawing their own conclusions based on an investigation that could involve talking to witnesses, which is okay and not considered double hearsay. But even if we didn't have this double hearsay problem, public records that are investigations are not admissible against a criminal defendant. So that's one of the sort of exceptions to the public record exception that you need to be familiar with for the exam. In addition, with respect to the co-conspirator exception, the statement occurred after the conspiracy ended. Usually by the time somebody is speaking to the police and has been arrested, that's a good indicator that the conspiracy is over and the statement is no longer during the course or in furtherance of the conspiracy. And so just keep that in mind because that's sort of an easy little rule to forget about and could get you in trouble on the exam if you forget that. And then finally, let's look at prior inconsistent statement. That one would be under 801 D1 instead of D2. That doesn't work here because for a couple of reasons. A police interrogation won't count as a proceeding. So you have to remember that you need a proceeding, you need a transcript, and you need an audience and an oath to constitute a proceeding. And here we just have a police report. In addition, Courtney is not a testifying witness, right? She's exercised her Fifth Amendment privilege. So 801 D1 will not work for that reason. If you'll recall, that exemption requires the witness to be testifying live on the stand. So let's look at this statement. What about this is the same statement, but what about the hearsay exception for statement against interest? So we're just looking at a different exception. Would that allow the prosecutor to admit this statement made by Courtney into Rachel Lee's trial? So the statement again is, Rachel Lee planned everything. I just drove her and Nick sometimes. So think back to the lecture on statement against interest. Is that statement a statement against interest? Let's start the question. You have three options this time. Yes, but only the part about Courtney's role. Yes, the judge will admit the entire statement. Or C, no. So take a minute, pause the video, and then we'll meet back here in a moment. Okay. So the correct answer for this one is A. Yes, but only the part about Courtney's role. That's really the only part that's truly against Courtney's interest, and so that's why that can come in. The judge would admit that part referring to Courtney driving burglars, but would have to take out or redact other parts, including the direct reference to Rachel Lee. So that's not very helpful to the prosecutor, obviously, in trying to convict Rachel Lee. The statement really loses a lot of value. It might still be useful for the prosecutor to sort of round out the picture of the entire conspiracy, but the juicy part, the part that incriminates his defendant, is not admissible under this exception. So now let's change the scenario a little bit. Let's say that Rachel has pled no contest and has gone off to prison. Alexis did the same. She went to jail and then to rehab. Now the prosecutors want to jointly try Courtney Amos and Nick Prugo. So as part of the case in chief, the prosecutor wants to introduce Courtney's statement to the police, and I'll show you the statement again. Rachel Lee planned everything. I just drove her and Nick sometimes. Now we already know that this statement is admissible against Courtney, right? She's the one who made the statement. This is just a classic opposing party statement under 801D2A. But the question is, can we admit, we're the prosecutor, can we admit the statement against her co-defendant Nick Prugo as well? And if not, will we still be able to use this statement against Courtney? Because if you'll remember, they're being jointly tried together. So by this point, the prosecutor has lots of evidence that Courtney and Nick worked together, so we clearly have a conspiracy. Does that allow the prosecutor to admit Courtney's statement against Nick as a statement of his co-conspirator? We will start the question. You have these three options. Take a look, pause the video, and then rejoin me for an explanation. Okay, welcome back. The correct answer to this one is no. We cannot use this statement as a co-conspirator exception against Nick. And the reason for that is, once again, the statement wasn't made during the course of the conspiracy, and it wasn't made in furtherance of the conspiracy. This is a statement made after the fact, where Courtney is really trying to shift blame. And the point is not to assist in stealing jewelry or anything like that. So no matter how clear the evidence of the conspiracy, we need those other requirements, and we don't have them here. Your second option was yes, but only with a limiting instruction. But you should know from your reading that a limiting instruction is not going to cure the kind of prejudice that would attend to Nick for a statement like this. And that's because of the Bruton issue that you read about in your textbook in the Evans and the Bruton case that we'll talk about later. So this is hearsay with respect to Nick. And if the prosecutor wants to use the statement against Courtney, the prosecutor is going to have to redact any reference to Nick at all. And the judge will also give a limiting instruction telling the jury really that they could only consider the statement against Courtney. So let's stay with the idea of a joint prosecution of Courtney and Nick, but let's change the evidence. Let's say that the prosecutor wants to call Nick's boss, so this is Nick's boss, as a witness. Imagine that Nick works the night shift at a local radio station, and the boss who supervised that shift would testify that Courtney begged him to give Nick the night off of September 23rd from work, and that turns out to be the night of one of the robberies. She tells him that they had an important project to work on that night. So the prosecutor wants to admit this testimony against both Courtney and Nick using the co-conspirator exception. First, the prosecutor has to, of course, persuade the judge that a conspiracy existed. So this is another question. To prove that a conspiracy existed, the prosecutor, A, may rely solely on Courtney's statement, B, may not rely at all on Courtney's statement, or C, may rely on the statement with other evidence. Go ahead and pause, and then we'll return for the answer. Okay, welcome back. The answer to this one from your reading is C, may rely on the statement with other evidence. And this is the requirement that appears in the last sort of provision or part of Rule 801D2. The statement does suggest that Courtney and Nick were working on a joint project, but we cannot rely on that alone. There has to be some sort of corroboration of that joint venture. Luckily for the prosecutor in this case, there appears to be plenty of other evidence of a conspiracy, including the surveillance tapes, statements from other members of the joint venture. So the prosecutor's probably okay proving that. So if the judge finds a conspiracy, is Courtney's statement admissible against Nick? Take a quick look at the statement one more time. And again, this is Courtney's out-of-court statement, right? So Nick is testifying as to Courtney's out-of-court, or I'm sorry, Nick's boss is testifying as to Courtney's out-of-court statement, begging for the night off. Can Nick have the night off? He and I have an important project to work on. That is the statement in issue. So if the judge finds a conspiracy is Courtney's statement begging Nick's boss to give Nick a night off from work on September 23rd so the two can work on a project that night admissible against Nick. Here are your 4 options: yes, or only if Courtney takes the stand, or only if Nick takes the stand, or no. Take a moment to answer and then press play. Okay, so this one's a little bit different than the other ones. The answer to this one is yes, and that's because we've changed the facts enough that this will fit within the parameters of the co-conspirator exception. The statement appears to be made during the course of the conspiracy. It happened before they actually broke into the house, and it also appears to be in furtherance of the conspiracy. Courtney was trying to get Nick free from work so that he could participate in the burglary. So she was attempting to further some aspect or goal of the joint venture. And we don't need either Nick or Courtney to take the stand for this exception to apply. And the statement of co-conspirator can be attributed to both of them. Okay, so now we're going to move on to, we've got 2 more chapters to go through today in your book. Those were the basics of the conspiracy exception. Remember, after this video that there will be a discussion thread. If you have any questions about anything we're talking about today, please do not hesitate to ask me questions in that discussion thread. So moving on to the residual exception. Be aware that courts really don't rely on the residual exception all that much. So you as a student, you don't want to overuse this exception. It really doesn't come up that often. Usually there's another exception that will cover hearsay, or a statement just is clearly rank hearsay and would not be admissible even under the residual exception. Occasionally, however, this exception is useful, so it is good to know about. There are 3 key requirements for a statement to fall under the residual exception. And this is just an exception when all else fails and you're trying to get a hearsay statement in, and you want to try to rely on this exception. So first, the judge must determine that the proffered statement has sufficient guarantees of trustworthiness. Second, the statement must be the most effective way to prove a fact and consequence, despite efforts to find other admissible evidence. And then finally, the proponent of the evidence must give notice to the other side of an intent to use the statement. So, and the other thing to keep in mind about this exception is the book chapter that talks about this section needs to be updated, right? Because the book was written before the December 1st, 2019 amendment took effect. So the book was written when the old version of the residual exception was still in effect. So just keep that in mind. There weren't a ton of substantive changes to the rule with the amended version, but on the exam, I'm going to want you to reference, if you get a question on the residual exception, I'm going to want you to reference the amended version. You have both versions in your book, so just make sure you're looking at the right one. And in this lecture, I'll go over the main, really there's one main difference between the two, the old and the new version. The new version is shorter, it's simpler, it's easier to interpret, so I think it's overall it's a good thing. The focus, instead of the 6, I think, different factors under the old rule, the focus is really now on 3 factors. One, the 3 I just mentioned really, is sufficient guarantees of trustworthiness, probative value, and actually I should have moved your slide here so you can see a copy of the amended version on your screen. So here you see there are like two main, A1 and 2 are the two main provisions, and then there's that same notice provision as in the old rule. So you're going to want to focus on sufficient guarantees of trustworthiness and probative value of the statement. With respect to notice, the main difference between the amended rule and the old rule is that the amended rule allows for the court to excuse a failure to give pretrial notice, so that a proponent of a hearsay statement can give notice during the trial as long as there's a good excuse for a lack of earlier notice. The biggest distinction between the amended rule and the version of the rule that's discussed in your textbook is that the amended rule does away with this near miss problem that your textbook talks about, I believe at pages 714 through 715. The amended rule adopts the majority rule with regard to the near miss problem. So it gives courts discretion to admit statements that are specifically covered by an exception in 803 or 804, but narrowly miss admission under one of those rules. And that's simply because the advisory committee changed some wording that appears in that introductory section of the rule. The advisory committee changed the specifically covered by language to the not admissible under a hearsay exception in 803 or 804, which I have highlighted in bold on the screen for you. So that's the relevant language. So again, on the exam, if you get a near miss problem, you're obviously going to want to apply the amended version of the rule. Under the old version, as you read, majority of courts applied this version anyways, but there was a minority that applied the literal language of the rule. Okay, so with that, we're going to just jump into a hypothetical. And actually, this is not a hypo because this is a real event, a real case. So this is a case in which the residual exception actually did prove useful to prosecutors, and it grew out of an older tragedy that occurred in southern Ohio. So there was a 16-year-old girl, her name was Cheryl Fossil, and she disappeared in 1977. Her body was found several weeks later. She had been beaten to death and decapitated. So police did not solve, this was one of those cold, unsolved mysteries. The police couldn't solve it. Some observers believe that the police maybe even participated in some sort of cover-up. So time passed all the way up to 2005. We have this woman in a hospital bed. Her name is Jean Ann Chin. She grew up with the teenager, with Fossil. She was dying of cancer in Florida in 2005. Chin told her brother that she had witnessed Fossil's murder all the way back in 1977 and had kept quiet about it for all of these years. Chin named two men as Fossil's murderers. She then, 2 months later, died of cancer. So based on this and other evidence, the prosecutor asked a grand jury to indict these two men for murder that were named by Chin on her deathbed. But the grand jury found the evidence to be insufficient in a criminal trial. I mean, all they had was the word of a woman who was no longer available. So meanwhile, despairing of any criminal prosecution, Fossil's siblings decided to file a civil lawsuit against these two alleged murderers, as well as against the county, claiming some sort of cover-up. So ultimately, the county settled the claims with the family, but the wrongful death claims against the two men proceeded. So in 2007, the wrongful death claims finally went to trial, but the defendant strongly resisted any testimony from Chin's brother about what Chin had said on her deathbed. So Jean's statement to the brother clearly would be hearsay, right? I mean, It's an out-of-court statement. It's admitted to prove the truth of the allegation, which is that the defendants committed the murder. So then we have to ask ourselves, do any of the hearsay exceptions that we've talked about so far apply? So first, let's look at present sense impression and excited utterance. Clearly, these two do not apply, right? This was a statement made many, many years after the event. She didn't appear to be stressed or excited. That wouldn't matter anyways, because again, these two requirements require substantial contemporaneousness. So this is just too long after the incident. What about a dying declaration? We talked about dying declarations. The trial court held that this was not a dying declaration. It occurred several months before the death, and most importantly, it didn't relate to the cause or circumstances of Jean's death, right? The statement related to the cause of somebody else's death, which is not covered by the rule. Is it admissible as a statement against interest? Now this one, the trial court held yes, it is admissible as a statement against interest because Jean Ann could have been prosecuted for covering up the crime in some way, such as obstructing justice. The Court of Appeals ultimately agreed, noting that Chin could have also been the subject of civil liability. But this is a really tough one, and it's a close call. A trial judge could have certainly decided this the other way, and a Court of Appeals probably would have decided that decision as well. Chin was in another state. She was old. She was close to death. She was speaking years after the crime. Did she realistically fear any sort of liability or criminal prosecution? Maybe not. So let's look at the last one. Excuse me. Is it admissible as a statement of a co-conspirator? The answer to this one is clearly no. The statement wasn't made in the course of the conspiracy or in furtherance of it. So what about admitting Chin's statement under the residual exception? Let's look at the three conditions that we now need to be satisfied for statements to gain admission under 807. First, are there sufficient guarantees of trustworthiness considering the totality of the circumstances and any corroborating evidence? So this statement does have guarantees of trustworthiness similar to those of the dying declaration, as well as to the statement against interest. There are other factors that the courts look to, including the 7 that are mentioned in your textbook at pages 716 and 717. Those include, was the statement made under oath? Did it describe something based on firsthand knowledge? Did the declarant ever recant? Is there corroboration? Is the corroboration subject to cross-examination? Is there any evidence that undermines or contradicts the statement? And finally, is there any incentive to lie? The next factor we want to look at is the statement more probative than other evidence the proponent could reasonably procure? And the answer really for this one is yes, it is more probative, just considering the age of the crime. It would be very difficult to find any other good evidence because of how long ago this took place. And then finally, is there a notice issue? The proponent would have to certainly provide notice before relying on 807, but that is usually not an issue. It's not hard to do, to provide notice. So what was the outcome of the Fossil case? Ultimately, the trial judge admitted Chin's statement, relying on both the statement against interest exception and the residual exception. And the jury awarded the Fossils over $1 million in damages and attorney's fees. The Sixth Circuit ultimately affirmed, finding that Chin's statement was admissible under both the statement against interest and the residual exceptions. So that's a good example of the residual exception coming into play to help the proponent. So take a look at this chart for a moment and notice how key elements of the residual exception line up with the general policies that we've studied so far behind most of the hearsay exceptions. The enumerated exceptions identify categories in which statements generally are reliable and or are more needed than most other statements. The residual exception identifies ad hoc situations in which reliability and or need are also very high. So it really makes sense from a policy standpoint. Okay, so next we have a hearsay review video from an episode of The Simpsons from 1993 that some of you may have seen if you were into The Simpsons. This is a good way to review some hearsay, so I thought it was worthwhile to play. So it's a short clip. The episode is called The Treehouse of Horror, number 4, and it's entitled The Devil and Homer Simpson. So I'll let you watch it. I'm not going to talk too much about it, but just know that the issue in this case was that Homer had allegedly signed some sort of contract with the devil, pledging his soul to the devil, but he had also pledged his soul to his wife, Marge, which is written on the back of a wedding photograph. So this is a trial, an imaginary trial that's taking place to determine who has proper ownership to Homer's soul. Does the devil have proper ownership to the soul, or does the wife, Marge? So the segment I'm about to show includes the entire trial, and what I want you to pay attention to is Homer's out-of-court statement that is written on the back of this photograph, this wedding photograph, and determine whether that out-of-court statement is admissible under the hearsay rules. Think particularly about whether it could come in under a specific exception that we've talked about so far. Some of the relevant exceptions we've talked about, perhaps dying declaration, statement against interest, the state of mind exception, recorded recollection, any sort of opposing party statement, and then think about whether it's admissible as not hearsay at all. So we'll go through it as soon as the clip is finished playing.
In a bar last night. The sound wasn't on, but I think I got the gist of it.
The Court of Infernal Affairs is now in session.
Very well. But first, some ground rules. Number 1, we get bathroom breaks every half hour.
Agreed. Number 2, the jury will be chosen by me.
Agreed. No, wait.
Silence. I give you the jury of the damned. Benedict Arnold, Lizzie Borden, Richard Nixon.
But I'm not dead yet. In fact, I just wrote an article for Redbook.
Hey, listen, I did a favor for you.
Yes, master.
John Wilkes Booth, Blackbeard the Pirate, John Dillinger, and the starting line of the 1976 Philadelphia Flyers.
I'm sorry, Mr. Blackbeard. We're low on chairs, and this is the last one.
This chair behind, says I.
I hold here a contract between myself and one Homer Simpson, pledging me his soul for a donut, which I delivered, and it was scrumdiddlyumptious. I simply asked for what is mine.
That was a right pretty speech, sir. But I ask you, what is a contract? Webster's defines it as an agreement under the law which is unbreakable. Which is unbreakable. Excuse me, I must use the restroom.
Mr. Hutz?
Homer Simpson, I have no choice but to sentence you to an eternity.
Wait! Before you send him to hell, there's something you should see. That's a photo of Homer and me at our wedding.
Wait a minute, you got married in an emergency room?
Well, Homer ate the entire wedding cake by himself. Before the wedding. Read the back! The back!
Tis some kind of treasure map.
You idiot, you can't read.
Aye, 'tis true. My debauchery was my way of compensating.
Dear Marge, you have given me your hand in marriage. All I can give you in return is my soul, which I pledge to you forever.
We've heard enough. Your Honor, we find that Homer Simpson's soul is legally the property of Marge Simpson and not of the devil.
No.
All right, Simpson, you get your soul back. But let that ill-gotten donut be forever on your head.
Homer, stop picking at it.
Oh, but I'm so sweet and tasty. Well, time to go to work.
Dad, I wouldn't go outside if I were you.
Don't worry, boys. He's got to come out of there sometime.
Great. So if you need some more time to think about it, feel free to pause the video if you'd like to think about whether Homer's out-of-court statement on the back of the photo pledging his soul to Marge can come in at a real trial, if this were a real case. So I asked you to think about several exceptions in particular, but first we're going to talk about whether there's an argument that this statement is not hearsay at all. You may have picked up on the fact that there's a good argument that this is not actually hearsay, that it's not coming in for the truth of the matter asserted, but that it's a verbal act or a legally operative statement, as it's sometimes called. So like a contract or a statement of permission, there's no truth of the matter asserted. All that matters is that Homer made a legally binding statement which created a legal obligation to pledge his soul to Marge in this case. So it should be admissible, just as the statement "I accept" in a contract would be admissible. So that would be sort of the easiest way to get this into evidence. But what about some of the other exceptions? Dying declaration. So Homer is unavailable, or at least he appears to be. This is a civil trial. It's a contract dispute. So, and he could have believed, I guess, when he wrote the statement that he was about to die, because you saw he was in the hospital and he had, eaten too much cake. However, the statement doesn't concern the reasons for the impending death, right, which is an important point or an important part of this exception. He doesn't talk about the cake at all. It's about something unrelated, so this doesn't apply. A statement against interest, of course, again, Homer's unavailable. The statement is a statement against his own proprietary interest because he gave something of value away. So this exception very well could apply. What about state of mind? The answer is no, it's not really a state of mind exception. The inscription on the photograph was a statement of a present action. So it's expressing something that Homer was doing or something he had done, if you change the language to "I have pledged." Now, if the statement were "I will pledge my soul to you forever," then it would be admissible as a state of mind, as something that Homer intended to do, expressing a plan. But again, it would come in as state of mind, though not dispositive proof that he had in fact pledged his soul, which is really the type of proof he needed and wanted. What about recorded recollection? Now again, if Homer was unavailable, that would not work, right? For recorded recollection, he'd have to be a witness and available. But if he was available, he could certify this as a recorded recollection. He would first have to state that he has no memory of whether he gave his soul to Marge, but that he made this record when his memory was fresh in his mind. He could then read the document to the jury, but it would not be admitted into evidence. And then finally, I asked you to think about an opposing party statement. No, Homer is a party, but this is offered by Marge, and Marge is acting as Homer's advocate in this case. So this is not an opposing party statement. So that's just a nice video to review several of the hearsay concepts and exceptions that we've talked about to date. So now we're going to move on to the last section or last part of your reading for today, which is Rule 806, dealing with attacking a declarant's credibility. This chapter focuses on material that we've covered in previous classes about attacking a witness's credibility, and it applies largely those same rules to a hearsay declarant, whether that declarant is in fact a witness at the trial or not. So first, let's review, to make it easy, let's review the rules governing impeachment and character evidence. So let's say we have 19-year-old Marlowe, who has been charged with committing an assault. He mounts an alibi defense claiming that he was at home mowing his lawn at the time of the assault. Now, while prepping for trial, the prosecutor discovers that Marlowe has a fake driver's license giving his age as 22 years old, even though he's only 19. And Marlowe has used this license to purchase beer and liquor at liquor stores. So at the assault trial, can the prosecutor use evidence of the license or of Marlowe's liquor store purchases? And let's think about all of the different potential ways the prosecutor would try to use this evidence of the license to attack this witness Marlowe's credibility. Can the prosecutor use the evidence in his case in chief? That's question A. B, if Marlowe calls a character witness who testifies that he is law-abiding. C, if Marlowe calls a character witness who testifies that Marlowe is peaceful and nonviolent. D, if Marlowe himself testifies. And then E, can the prosecutor introduce extrinsic evidence if Marlowe denies any of this? So if you'd like to, now would be a good opportunity just to pause the video and try to answer these 5 questions, and then hit play. We'll go through each of them in turn. This is not a top hat question. Okay, so let's start with A. Can the prosecutor use this evidence in its case in chief? The answer to that one, hopefully you all remember, is no, and that is based on Rule 404A. Remember that Rule 404A prohibits this type of propensity argument. It's a pure and simple propensity argument, and an argument like that is not admissible in the prosecutor's case in chief. B, what if Marlowe calls a character witness who testifies that Marlowe is law-abiding? Yes, at this point Marlowe has quote-unquote opened the door to this type of evidence coming in, and what it really is, think about it as impeachment of Marlowe's character witness, right? Because Marlowe has called this witness who claims to know Marlowe well and who's willing to say that Marlowe is law-abiding, which is, remember, a very broad term. If a witness uses that term law-abiding, that should be a red flag to you that, uh-oh, we're now opening the door for all kinds of evidence of breaking the law to come in to really kind of impeach the character witness, frankly. You're suggesting that the character witness really doesn't know Marlowe as well as he or she claims, or that the character witness is just simply lying or covering up on Marlowe's behalf. This is similar to the Michelson case that you read. So if you struggled with this one, go back in your reading or your outlines and review the holding of the Michelson case. What about if Marlowe calls a character witness who testifies simply that Marlowe is peaceful and nonviolent? So what's the difference between C and B? The difference is that this character witness has been more careful and is using specific pertinent character traits. And remember, this can come in under the mercy rule, so the defendant can introduce evidence of his own pertinent character traits. This is an assault trial, right? So peacefulness and nonviolence is certainly pertinent to whether somebody would commit an assault. But this witness has been more careful and is using more narrow language. So on these facts, no, the prosecutor is not going to be able to introduce evidence of the license because the license doesn't relate, or the liquor store purchase and the license, neither of them relate to peacefulness and nonviolence. So remember that there's this matching pertinent traits rule as it relates to the mercy rule. The prosecutor has to match the pertinent trait raised by the defense. Now, what about if Marlowe testifies? If Marlowe testifies, then yes, he can be asked about the fake license, and he can be asked about purchasing beer or liquor, because both relate to character for truthfulness. Right? They're both examples of untruthful conduct, and there's specific instances of untruthful conduct that can come in under 608B. Finally, can the prosecutor introduce extrinsic evidence if Marlowe denies any of this? And hopefully you remember the extrinsic evidence rule. Extrinsic evidence is not admissible under 608B unless Marlowe was convicted of a crime. Then potentially evidence of the conviction might come in under 609. You'd have to look at the rule. So now let's apply these same impeachment rules to a declarant rather than a witness, and just to make it easy, we'll stick with the Marlowe example. So let's say that a jury acquits Marlowe of assault, and on the way home from his trial, Marlowe saw a car run a red light and hit a pedestrian. Marlowe shouted, "Hey, that car ran the red light." He then suffered a heart attack and he died, unfortunately. So many of these hypotheticals are sad, I apologize. Let's say that his girlfriend Julia was a passenger in the car with Marlowe, but she didn't see the accident. She was on her phone. But she did hear Marlowe shout out, "Hey, that car ran the red light." So let's say the pedestrian who's hit by the car sues the auto driver for negligence and wants to call the girlfriend Julia as a witness at trial. Julia relates the shout, and let's say it's admitted as an excited utterance. You could see how that would likely be an excited utterance. How can the auto driver, the opponent, impeach Marlowe's credibility? And again, the focus is on Marlowe's credibility, not on Julia's credibility, because Marlowe is the declarant. Marlowe's the one who made the statement, "Hey, that car ran the red light." So again, there's several ways that we can impeach Marlowe's statement. We can call a character witness who will testify that Marlowe had an untruthful character, and/or who will testify that Marlowe had a reputation for untruthfulness. But again, under the impeachment rules, under 608, we're not going to be able to ask about specific acts, like the beer or the license. And that's because this is direct examination. You can only testify about opinion or reputation evidence. Now, if the pedestrian rebuts the character evidence by calling a character witness who testifies to Marlowe's truthfulness, the driver can cross-examine that character witness about specific acts. The driver can try to impeach Marlowe's perception of the accident by cross-examining Julia about what he was doing when he made the utterance. So, for example, how can she be so sure that he saw the collision? Maybe he was distracted by something. I have a friend who used to read novels while driving. I always thought it was really strange and not the best idea. You'd like, if you pull up next to him, you'd see him literally with his face in a novel while driving. So rare, but perhaps there's a chance that Marlowe did those types of things as well. And then you have the Sada case. That case suggests that a party may cross-examine the witness who relates hearsay about conduct related to the declarant's truthfulness. So since Julia was Marlowe's girlfriend, this is a plausible tactic in this case. Perhaps the driver can ask Julia if she was aware of the fact that Marlowe had a fake driver's license and was purchasing alcohol even though he was underage, right? So these are specific instances, but again, this is on cross-examination of the witness who relates the hearsay, which happens to be the girlfriend. She may well know about the fake license. The driver cannot introduce extrinsic evidence of Marlowe's untruthfulness, although one court in the Second Circuit has suggested in dicta that this might be fair. So this would be the opposite holding of the Third Circuit SADA case. Most courts have interpreted the Rule 806 as incorporating Rule 608B's ban on extrinsic evidence of specific acts. So just be aware that there's sort of a majority opinion on that and then minority opinion in dicta from the Second Circuit that says, well, perhaps we should admit extrinsic evidence because it's more fair to the proponent of the evidence, considering Marlowe is not available to talk about the fact that he has a fake license and has bought alcohol before. So let's return to the Fossil case, in which Jean Ann Chin spoke to her brother as she was dying. Remember that the year was 2005. She told her brother that she witnessed the murder of this teenager in 1977. She named the two men responsible, and the court allowed the brother to testify at a civil wrongful death action against the two men under the statement against interest and the residual exception. So let's say that the defendants offered evidence that Chin, so Chin here is the woman who made the statement and who's dying of cancer, that she was using narcotic pain relievers when she spoke to the brother. There was nothing illegal about the medications. She was in hospice. She was dying of cancer. The question is that evidence that Jean Ann Chin was under the influence of narcotic pain meds admissible at trial? So here are your options. Either A, yes, it affects her credibility. No, because Chin's not a witness. C, no, because it's unfairly prejudicial. Or D, no, because it's extrinsic evidence. Take a moment to answer this question, hit pause, and then when you're ready, hit play, and we'll explain the answer. Okay, so the answer to this one is yes, A. It affects Chin's credibility. So the jury might still believe that her statement is true, as relayed by the brother, but they are also entitled to know that she was under the influence of these heavy painkillers when she spoke. Again, Chin does not have to be a witness to for her credibility to be attacked. That's the whole point of Rule 806. It applies the impeachment rules to non-witness declarants. Rule 806 allows parties to attack a declarant really in the same way that we would challenge any witness. This information is not going to be considered unfairly prejudicial. It's simply a classic example of evidence related to witness competency. The evidence is extrinsic in this case, yes, but that's okay. Remember the rule that extrinsic evidence is admissible to show that a witness or a declarant is biased or has memory or perception problems or impairments. That kind of information is never considered collateral, right? So extrinsic evidence can come in. And this is in juxtaposition to like evidence of a prior inconsistent statement, for example. A party can't use extrinsic evidence to show inconsistent statements on a collateral matter or to prove dishonest acts that the witness denies that have nothing to do with this trial. But nothing stops the use of extrinsic evidence to show impairment of mental faculties. Here's another question based on the fossil case. What if the defendants had evidence that Chen had been convicted of assault? Is that admissible? Here are your options. A, no, she's not a witness. No, that's character evidence. No, assault is not a crime of dishonesty. Or yes, if it was a felony conviction that satisfied Rule 609. Take a moment to pause, answer this one, and then we will explain. Okay, so the correct answer to this one is yes, D. If it was a felony conviction and if it satisfied all of the parameters of Rule 609. So Chen isn't a witness, but again, Rule 806 treats declarants as witnesses. Now, felonies qualify even if they're not a crime of dishonesty. So it doesn't matter that assault is not a crime of dishonesty, because if it's a felony, it's going to automatically, potentially qualify under the rule. Now, keep in mind, one of the requirements of Rule 609 is this 10-year time limit. And so there could be sort of an ancillary question here. Do we measure that by the time of trial or the time of the statement? And I'm not really aware of any particular rule or law on that, so you could argue this one really either way under the rules. The plain language might prefer the time of the trial. For example, 609 refers to time of trial, and 806 says if a declarant had testified as a witness. So the language seems to refer to the time of the current trial. But you could also argue that the testifying occurred earlier, including when the declarant spoke. So the court should consider credibility at that time. Okay, I believe this is the final question. What if the defendants had evidence that Chen had lied to her insurance company? She was never charged with or convicted of any crime, but you as defendant's lawyer have talked to the insurance agent who has shown you paperwork that documents Chen's lies. What is the most likely way to tell the jury about this information? 4 options. A, introduce the testimony of the insurance agent. B, ask Chen's brother if he knows. C, call a character witness. Or D, there's simply no way to do this. Take a moment to answer, and then we'll review the answer to this one. Great, so the answer to this one is B, ask Chen's brother if he knows about the lie to the insurance company. We probably cannot introduce evidence, extrinsic evidence, such as calling the agent to testify. Remember, this is again goes back to the SADA case and the issues raised there. The Second Circuit suggested in dictum that it would be fair to do this, to call the insurance agent, but the Third Circuit and the majority of other circuits have rejected that position. In fact, no other court has followed the Second Circuit's suggestion. As far as character witness, a character witness can only offer opinion about Chen's character and cannot refer to specifics. Here we have a specific act that we want to get into evidence, so calling a character witness is not going to be helpful. Your best bet is hopefully Chen's brother knows about it and is aware of this incident, and then you can simply cross-examine Chen's brother on it. The last series of slides just sort of summarizes 6 points for you to remember and to know about Rule 806. First is that it applies to all hearsay except 801D1 and 801D2A and B, and in those scenarios the rule simply isn't needed. With 801D1, the declarant is also a witness, so Article 6 automatically applies. And then with 801D2A and B, the opponent would be attacking his or her own credibility, which he wouldn't ever want to do. And remember, this does not apply to non-hearsay statements that are not offered for the truth of the matter asserted. The second point is that it applies to any evidence that would be admissible if the declarant was a witness. And I give you a list that you can take a look at of different ways to impeach a witness or a declarant. Keep in mind that 608B dishonest act evidence is not included in the list. 608B evidence can come in if the declarant testifies as a witness. The character evidence rules allow, right, an opponent to cross-examine a witness about specific acts of dishonesty. But again, what if the hearsay declarant does not testify? It goes back to the same issue we've talked about several times now with the circuit split between the Second Circuit that has suggested that you can introduce extrinsic evidence of dishonest acts, and then the Third Circuit and the majority of other circuits that say that extrinsic evidence is not admissible, that we have to hold to strict adherence to the extrinsic evidence rule in order really to avoid turning this trial into a mini trial on a collateral matter, which could distract and confuse the jury. And again, the court held in SADA that if the witness reciting the statement knows the declarant, you can simply cross-examine that witness about the declarant's dishonest acts. Third, once a declarant has been impeached, the other party may certainly rehabilitate in any way that is permitted with any witness. Declarant's inconsistent statements are admissible without giving the declarant an opportunity to explain or deny the inconsistencies. And that simply makes sense because the declarant may not be a witness. And so if they're not a witness, they would not be able to explain or deny the inconsistencies. 5, the rule allows any party to impeach a hearsay declarant, even the party that offers the statement, which is unusual, but again, this sort of tracks the language of Rule 607 for witnesses. And finally, the opponent of the statement may want to call the declarant. If the opponent does so, she may ask leading questions as if on cross-examination. And this overrides Rule 611. Okay, so that is the end of our lecture for today, class number 23. And we have a few more to go, so stay tuned. And again, remember, if you have any questions on the material that we covered today, please ask me those questions in a discussion thread on Top Hat. All right, I will see you next time.